Topic here is European laws from the book The Gay Past. So before we begin, we have to have an understanding of these particular terms, buggery and sodomy. For the most part, we're looking at the crime against nature. And why is it a crime against nature? Because the end result of the sexual act does not lead to the production of a child. So when we see the phrase crime against nature, that's kind of where they're going. Such acts would be considered vice, immoral, or wicked. And when we see the reference to sodomy, we are talking about a reference to Sodom and Gomorrah, which is a story that can be found in the Bible. As it says here, Book of Genesis talks about that particular, story from the Bible. So here we go. Let's take a look at some of the laws. So in this particular law here, we see the reference to somebody being proven to be a sodomite. Again, this is a reference to Sodom and Gomorrah. And we look at the punishment here, which is burning. So for the committing of this particular crime, the end result is going to be death. And if you are a woman, the same result can be applied here. So we see two laws, one targeting men, one targeting women. The end result is if you are proven to be a sodomite, you are going to be burned. Let's take a look at this law from 1533. We see abominable. And this is a reference. Once again, you'll see how this, the impact of this particular word later on, an abomination, the punishment of death. And when we look at this particular law, we're changing here. We see natural use. So again, crime against nature. We also see the reference to the committing the vice of sodomy. Punishment, burning outside of the city. So we see some similarities between the laws with regard to the legal language that is being used for both. All right, let's look at this Roman language here. Relations with another woman. So this one is targeting, women. And it has the language here about a material instrument. Keep in mind, two women are not going to be able to produce a child. So again, it goes back to the crime against nature. Punishment, burning. Let's take a look at this law here in the 1500s. For the first issue here, they're identifying three kinds of sodomy. Again, a reference to Sodom and Gomorrah, the punishment of beheading. And so in this law here, notice how they also bring up bestiality. So, man, woman, seems to be on somewhat of the same level as man with beast. So when we look at this law here, this is the one I was saying where it uses the word abomination. And so for this particular section here, we're looking at Leviticus 20:13. If man lieth with mankind as a man lieth with woman, that's the act that they are identifying here. And in this case here, it talks about they have committed an abomination, and the end result will be death. They also use the word natural, again, the crime against nature has been mentioned. So it's interesting to see how all of the laws that we looked at from this particular point and its influence in the United States. Here we have Pennsylvania sodomy law from the 1600s, and we have something here from New Jersey, again from the 1600s. And again, it seems to be very similar. They're using the crime against nature. They're using the language, the word sodomy, reference to Sodom and Gomorrah. And here we see New Jersey, this particular sodomy law. So there definitely seems to be some similarities with regard to the reference of Sodom and Gomorrah, the crime against nature, the punishment being very similar for these laws. And that's why I brought up started with this particular slide to kind of reinforce that point. But for the most part, they seem to be concerned about the end result of the act. Is it for enjoyment or is it for the reproduction of a child? This particular slide here is in, again, the Gay Past, and the point of this particular section was to look at the myth of lesbian impunity. Are man and man targeted at the same level as women and women? And so here we see a list of women that were found guilty of violating the laws, and you can see the punishment here for drowning, or end result being drowning, beheading, whipping, banishment. So the myth of lesbian impunity, again, it brings up the question: have two women been targeted historically? We could see the dates here from the 1400s going to the 1700s, and these are just the cases that we know about. Which brings up the trial here between these two individuals. So here we have two defendants. We have Catharina Linck and Catharina Margaretha. Notice here the age. We could also look at past history. So in this particular case, this involves two women, and both women are going to be on trial for violating some of the laws, and we already know what's at stake here: death. If both of them are found guilty, it's very likely that both will be sentenced to either some sort of hanging or beheading. Who knows? So when we're looking at the two individuals here, if you notice, the defendant, the one on the right, is dressed as a soldier, and the one on the left seems to be dressed as a female. And so that's kind of what I'm looking at. We also notice the age here. And so we know that both of these individuals are possibly going to be punished for their crimes here, crimes against nature. But they have a relationship, and these two women are married. So it raises a lot of questions. And think about this case here. They've been married. And the question is whether or not the co-defendant, was aware that the husband was a woman, because that seems to be the issue here. The question is, does the co-defendant know that the woman that she's being accused of having a relationship, did she know throughout this marriage that this was a man or a woman? That seems to be the question here. So here we see the two, individuals, and the situation is that the mother reports to the authorities that her daughter does not know that the man was actually a woman. So keep in mind that if both of these individuals are going to court, going on trial for their crime, they both run the risk of being beheaded or burned or something. So we look at this particular trial. The mother's testimony, she's raising some questions here. She's saying that, the woman disguised herself, that the woman her daughter was married to has dressed like a man, and during the marriage, her daughter did not know that the husband was actually a woman. So you need to think about that. As we're going through these slides, think about, if you're on the jury, if you're the judge, how you would, what questions would you have for this particular case? So that seems to be what's going on here. That she wore, wore male and female clothing for 3 to 4 years, and so the question is, how could her daughter know or not know? What did she know? What did she not know? With regard to any reproductive organ, the defendant here is being accused of making some sort of instrument that mimics a male penis, and that's why the one law talked about the use of a material instrument. So the mother's testimony, I don't know what the mom's issue is here. Remember, the mom reports the situation, and the mom is probably looking at this like she wants to make sure that her daughter is not going to be found guilty and punished. So that seems to be the mom's motivation here, to make sure that her daughter, at a bare minimum, stays alive. So they bring up the issue of how many times, the two engaged in any sort of sexual act. And again, if they're engaging in any sexual act, what could the co-defendant actually know? The co-defendant is this person right here, the woman, or the person that's playing the role of a woman, however you want to word it. The defendant did not know that, whether the latter had complained about this to her mother. The defendant did not know. So these are the questions that are being raised here. Let's take a look at Linck's defense here. So in Linck's defense, she says that the mother-in-law and the bride, they did know that she was a woman. and that they had been married not just once, but also 2 times. And, if the daughter is willing to get married not once, but twice, then the daughter had to know something. So that's kind of some of the defense that she has. And then Linck's defense, and again, this is the woman who may or may not be dressing up as a male to trick her wife into believing that she is in a male-female marriage. So they bring up the issue as to her wearing men's clothing, and she argues that other women had done this before. So what really is she doing wrong? That with regard to any sort of sexual encounter, that the wife did not suffer any pain through the act of the sexual act. That there was some sort of enjoyment that was yielded from the exchange. With regard to taking things from the wife, she's saying that she wasn't, if she did take anything, it's because she had supported the daughter through the marriage. And so this brings up questions about patriarchy. Mohan's defense, arguing that she had endured pain throughout the exchange, throughout the marriage. So if she's experiencing any sort of pain and suffering during the marriage, this raises a lot of questions. Why is she staying in the relationship? Does she really know that this is a woman? And so on. They also bring up in her defense that she had not noticed that the instrument being used in the sexual act. How is she supposed to know that this is, if what is her sexual history? If she has never engaged in any sexual history before the marriage and this is her first sexual encounter, how is she in a position to really know what body parts look like, what sexual acts feel like, and so on? So she seems to be arguing that throughout this marriage, she was under the impression that the man she married is a man, and not once did she, think that this was a woman. Because if she's under the belief that this was a woman, then she's probably going to be found guilty. They also look at the issue of urination here. And here the co-defendant and the co-defendant being the woman, is arguing that, she noticed that her husband, would always have urine on her shoes. And, the question here, and they bring up the point, well, other men can piss, right away. So it's looking at if this is a male and a female urinating, the male would be able to urinate a couple of feet away, whereas the woman, just as a result of biology, is probably more likely to urinate on her shoes. And these are things that are being used at the trial to either prove or disprove that the co-defendant here did or did not know that the person she was married to was a woman, as opposed to being a man, which she believed that it was a man. So the closure questions are here. And keep in mind that, point 2, how could the punishment influence court cases and the behaviors of closeted homosexuals? We go back to the Mohan Linck case. Why is the mother reporting the case? At a bare minimum, 2 people are about to get executed. Is it better for both parties to say, I'm going to be in agreement? I didn't know you were we're going to say I didn't know the whole time. You tricked me. And, that will at least save one of us from being beheaded. And the end result of the case, the defendant's beheaded, and the co-defendant, the woman that was playing the role of a woman the whole time, she does receive a lighter punishment.